Many of our clients have heard the phrase alternative dispute resolution. And alternative dispute resolution takes many forms, and the alternative is an alternative to going to court. The most popular forms are arbitration and mediation. And although people think those are the same things, they are completely different things. Arbitration is typically done by agreement. Sometimes an employee doesn't realize he has entered into an arbitration agreement when he signs a form employment agreement. But many of those form agreements today with big companies have arbitration provisions which require you to resolve a dispute by arbitration rather than going to court. Arbitration is more like a judicial forum in that there is one arbitrator. There could be 3 arbitrators, a panel of arbitrators, but the arbitrators act as judges. They're there to hear evidence, to take testimony, look at documents, and render a decision. I'm not saying that the arbitrator won't try to settle the case, because he or she or they will, but they are there to perform the function of deciding the case. The arbitral forum may be less expensive depending upon the case. There may not be as much discovery, i.e. depositions, exchange of documents, although there will be some. There are few rules of evidence that can be beneficial or not, depending upon your point of view. But it typically takes a shorter period of time to come to resolution. When an arbitrator or a panel decides a matter, there's virtually no way to challenge it. Most arbitration provisions say that the arbitration decision is binding unless the arbitrator or the panel has exceeded their given jurisdiction, which is set out by agreement. In the case, and it happens rarely, where that jurisdiction is exceeded, there are provisions in the New York State Civil Practice and Procedure Law, Section 75, Article 75, for challenging that, but it almost never is successful. Mediation is a very different forum, and a mediator has very different skill sets from an arbitrator. A mediator, and typically it is by agreement, but there are times when it's mandatory, and I'll talk about that in a second. A mediator is on the scene to bring the parties together to resolution, not to decide who's right and who's wrong in the dispute. And it represents a different focus and a different set of abilities. I say that mediation is voluntary, but that's not always true. Parties can always agree to mediate a dispute. They can hire any mediator they choose, or they can go through one of the many mediation companies that are now around the country, and many in New York area. But there are now other provisions. For example, in the federal court in New York, the United States District Court for the Southern District of New York, if you file a complaint and the only claim in the complaint is discrimination in employment, the court will direct you to go to mediation. And in that case, it's a mediation before a member of a panel of voluntary mediators, mediators who are attorneys who are performing free service as an aid to the court. It is not always a mediator who has any experience, for example, in employment discrimination law. They may be securities lawyers, they may be criminal lawyers, but it is a mandatory program. And while we initially felt that that program would not be successful, I would say that we have resolved cases in that program with mediators who knew nothing about this area of law, without the need for extensive and expensive discovery, exchange of documents, deposition, and trial.